theory for why they had to take a hold?
Initially, they made a whole bunch of different allegations where drug lords, drug addicts, criminals running from the law, terrorists, you name it, they thought of it and accused us of it. But on paper, they said that it's because the parents were unwilling to cooperate with the department for the care of the child.
That's what they claim is the basis for the hold?
Yes. That's the paper, the paper they gave us at the hospital. That's what it said.
That's insane. I mean, that's...
Exactly. That's exactly what we...
It's not imminency. That's the legal standard is imminency.
Exactly.
And then the 10-day was where you couldn't continue. Yeah, they can't continue the 10-day hearings by statute, unfortunately.
Yeah.
I mean, what needs to be done, honestly, is a motion to revoke the OTC has to be filed, and it has to be scheduled for a hearing if DCF is not going to voluntarily return the child. That is your only recourse at this point. Or if DCF is willing to accept the NOLO plea and send the child back to Tennessee under protective supervision, I mean, that's the other quickest way. Those are literally the only two options available.
Okay, but a NOLO plea I don't think would work for us because in Tennessee they can use a judgment against you or a guilty plea to terminate our rights for our other boys and possibly escalate it to criminal.
It's not a guilty plea. A NOLO plea the NOLO plea itself is not an admission or denial of anything. It's not. It's not a guilty plea. It's not even close to a guilty plea. Juvenile court uses a completely different legal standard. They use fair preponderance. They don't use beyond a reasonable doubt. And the only way that the termination, I don't know about Tennessee, but Connecticut law is clear. A finding of neglect is not a basis on which to file a termination petition. There has to be some other factors. Failure to rehab, you intentionally inflicted injuries on the child, etc. Tennessee may be different. You may need to consult with a Tennessee lawyer. Yeah. But I am telling you, the only way to dispose of this case is file a motion to vacate the OTC, and if you win, you don't have to enter a NOLO. If they don't vacate the OTC, you have to have a neglect trial or a motion to revoke the commitment and demonstrate by a fair preponderance that there was no statutory neglect.
Okay, but we don't believe that they had any right to take our child. I mean, what basis are they making all these kinds?
So that argument is not an argument that a DCF attorney like myself would use in juvenile court. There's no affirmative defense to an unconstitutional taking. What you are complaining about is a civil action against DCF after the fact if you get the OTC vacated.
Okay, so
your time to challenge the OTC was when you couldn't make it, unfortunately.
Okay, so what can we do to vacate the OTC? Do you think we would actually have a chance?
You have to file a motion.
Would you be able to help us do
that?
Well,
that's contingent on a couple of things. For one, you have to just file an actual motion to vacate the OTC. We also have to see the court filings before we filed anything.
Okay.
Yeah, my office handles this, but it's a question of, I'll be honest with you, it's a question of funding. This is not a cheap case by any stretch of the imagination.
How much do you think we're looking at?
Hey, I'm on the phone.
Okay, yeah, I think they were bringing him in.
All right.
He's out there.
All right, thank you.
Yeah.
I'm sorry, I get distracted.
That's all right. How much do you think we're looking at in terms of funding?
In terms of a retainer on these files, our typical retainer, if it's a motion to vacate an order of temporary custody and or a motion to revoke / neglect trial, the retainers are $15,000. We bill it $250 an hour. And I can tell you my last OTC I did took all of about it was $27,500 is what we told that client totally spent.
$27,500, and you need $15,000 as a retainer?
As the retainer, correct. That's what we bill against.
Okay. So does the fact that they already ruled against us have any impact on the motion to vacate the OTC?
No, because the motion to vacate, the legal standard for an OTC is imminent risk. There's also a part of our statutes which is very clear that DCF has an affirmative duty to return the child to the parent when there is no longer any imminency. The argument in your case is that enough time has passed for them to do an adequate investigation to demonstrate that right now, as of today, there would be no imminency as to your child returning to your care. That's the legal standard. They don't look at whether or not the parents were defaulted or not. They don't even look at if there was a contested hearing or not.
Okay. So do you think we actually have a chance if we file this motion, or?
I would, before I could say that, I would say this. If what you said to me is the sole basis for imminency, that the parents would not cooperate with the department, then I think, I think you have a very good case to vacate an OTC. That's not a basis to hold a child. And just simply, you file the motion to vacate, you would argue, look, if there was any finding that this child was neglected, the parents would cooperate. But that doesn't even deal with the neglect. That's just the order of temporary custody that's in place.